Hello. 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 1, 2, 1, 2. There she is. Oh,
Oh, hang on.
we're just jumping right into it.
There we go. I was trying to join the chat. I think it
Oh,
took
you
me
want me
out
to
for
do that? You want me
when
to
I did.
take you out for a minute?
I think it let me, but I think it popped me out for a second. I was trying to
Wait,
do that quickly. Sorry.
wait, hang on a second. Hi, everybody.
Hello.
We're just clearly just ready to go.
Yeah, we're winging it.
Wait a
Hello,
minute.
everybody.
Do you Hello, hi. Morning. Okay, so morning. Wait, I forget where everybody, where's morning? Tell me where morning is. Just gonna say some hellos. Um, hi, hello. Uh-oh. Hi, hello. I don't know why. Do you see on the screen here where the chat is coming up? You see
Mm-hmm.
that? Why is that? Did I do that? I
It,
did.
it might be one of the what do you call it?
Oh,
Either
wait, I
one of
got
the
an idea.
layouts or it's on one of the settings
All right, damn it.
somewhere.
You know what? You know what? This is some coming in hot.
I just saw that a second ago. I want to say if you click, you can maybe not.
I thought it might have been overlays, but
That's funny.
I know. So what's everybody up to? I'm trying to go through here and take it off. Um, look who's here. Hi. Hello. Yeah, so I'm trying to just pull down whatever this is that's going on, but tonight we're gonna go through I'm going to say hellos, but I want to get this out before I forget because we're going to go through just sort of a line by line of the motion to correct errors. And All Eyes has done an amazing job with her timeline. We're going to pull that up so we can all kind of follow along. I think everybody has pretty decent access to all the filings if they're interested in filing, if coming along. But my idea was that this way everybody can go through literally line by line and pick apart what it is that we see, what we have, what we don't have, and kind of go from there and break it down. I know a lot of people have been doing calls and lives and things about evidence. This is kind of like that, but with the motion to correct error and some of the filings in that sort of critical post actual conviction and sentencing month or two. There's a lot of stuff that happened, and I think it's time to go back there. And I don't know, is that kind of what we talked about?
Yeah.
I mean, that seems to make sense, right?
Yes. I mean,
Okay.
I have no notes on that. I just agree.
100%
Yeah.
no notes.
Yeah.
So what we're gonna do, let me see though. Let me see if I can you guys talk amongst yourself for a minute. I'm gonna try to get rid of this. This is driving me nuts.
I want to say there should be a setting somewhere that is to remove the comments from the stage. I don't know where it is
Uh,
on. I wonder if I was trying to actually pull up a different window on mine to see if I could figure out where. I do know somewhere there's an option for
Listen,
to remove it from the stage. I just don't know where. I'm trying to
yeah,
look though.
I am too. All right, well, let me know if you're cool with trying to figure that out. I'm trying to look at the overlay. Hold on. No, that ain't it. It would have to be in anybody in the chat now? Anybody? I feel like I'm talking to my grandmother and it's me.
Hang on, let's see.
Oh, oh shit.
So they left my replay for this. That replay last night was me just, I guess venting is probably the best word. I just get so frustrated when when there's
Oh,
still so many questions. But yeah, I tried last night to at least explain that I'm coming from a place of just wanting answers, that I am aware that sometimes I'm direct and a bit harsh, but it's coming from a good place, and I am working on it. I am trying to be softer about it and more diplomatic, all of the things, because I am actually trying. But
What happened?
there's
What are
so
you
many.
talking about?
I did a impromptu live last night after reading
Yeah.
through the juror transcript,
Oh,
the
Lord have
interview,
mercy.
and
Do we
I
have to spend a minute on that, or do we not
well, I
need
guess we could
to?
do a minute just so that we
Okay.
don't leave it hanging. But
Okay. Yeah.
there was a juror interview on the Unsolved channel, and I I just have a lot of questions for the juror. Her notes were factually different than the prosecutor's motions, than well
Okay.
as testimony. There was a lot of that kind of stuff. I mean, I think we could all find things to disagree on when it comes to her observations of things.
Mm-hmm.
But aside from even those, my actual issue was the factual errors.
Mm-hmm.
And how do we proceed when these jurors are coming forward with information that is in direct conflict and contradicting what the actual court record shows?
Mm.
And just like had and because of the tension between the people who see things differently, sometimes it's difficult for us to have hard conversations about those things
Sure.
because, it in some ways it can be person versus person, but I'm trying to find an avenue, a lane to where we can still have the conversation, because
Yeah.
sometimes the state side tends to get information first, and it's selective, and there's this information gap sometimes,
Yeah.
and I have
Yeah.
a hard time with that, because for me, I would like to make it available to anybody and everybody, as much of it as possible, so that we can all actually have the same conversation.
Yeah.
But yeah,
Well, and
that's
I
kind of
mean,
what it was, and there are
mhm.
some questions about whether or not she really was one of the jurors,
Yeah.
and there's a
Well,
lot of stuff there, but
but I think so. I mean, I think that okay, I get it, and I
yeah,
think too that that's why, and I always like to bring it back to the fundamental lack of transparency from
absolutely.
before, and I think that people lose sight of that, and that it's okay to ask these questions
Yeah,
because of course you're going to ask these questions, right? I mean, my
yeah,
God, there's been nothing. I mean, you can't even get access to all of the exhibits that the state bought, right? I mean,
yeah.
and that's don't even get me started on that. But I think it's all it well, there's just some bad actors out there, but at the same time, I do think that there's a lot of frustration. I think it's okay to recognize that it and try to redirect it back to where it needs to be, and that's like one of the reasons you have trial streaming and open records and open courts is because of this kind of shit.
Yeah.
You know, it's because this very thing. It's like, well, we wouldn't have to guess necessarily if this person is telling the truth about being a juror or not. We wouldn't have to rely on,
And we probably wouldn't
any
be
of
as
that.
frustrated as we are either if we hadn't spent the last 2 years arguing over this insider close to the case said this, or that,
Right.
or innuendo, or stuff that none of us had anything until very recently. None of us had any actual, like, across the board, this is what the facts are according to the record. We didn't
Mhm.
have that really tangibly, materially to argue over. It was really just arguing over theories, and that drowned out a lot of the discourse about, like, that I've been trying to have. I don't have a theory. I have more questions than answers. I do have plenty of reasons why I think he's innocent, and I'm happy to argue those and
Mhm. Mhm.
articulate them and dissect them and all kinds of things. But I don't have an actual theory, and that is ultimately probably my biggest issue with this case is victims deserve to have their crimes solved.
Absolutely. And
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 in a way that we can stand up and be like, if this person wants to file an appeal, screw them, because we know what happened. This is what happened. It was proven. We don't have that though in this, and
Right.
That eats at me on a whole other level than the other stuff, but I'm also I can I can care about more than one thing at a time. Like, the state forced me to care about this defendant and
Right.
his violation of his right. Like, these systemic
Hmm.
issues are important to
And
me
they,
because they affect what happens to victims and the justice they do or don't get. And that is, it kind of is all intertwined, but that is where my frustration comes from. And it's not a it I don't have a team in this.
right.
I just want it whichever side is willing to give them. Like, I'll probably be more grateful to them, but ultimately the state, like, they're the only ones who owe us any answers.
Yes, correct. Hello, ding, ding, ding. And
Yeah,
that's,
and they're
and
not
that,
playing ball, and they don't care, and there's no
right,
recourse.
right. And they,
Or there
yeah,
hasn't been, I guess, at least as of now, but yeah.
yeah. And I hate, and the thing is that that's part of the, when you and I first spoke about this, I was like, I really want to just go back into the documents because this is basically the throat clearing and everything on the table that the state needs to answer for.
Yeah.
It doesn't mean so like when we talk. So let me do this. Well,
Well, people are
um,
very quick to say, "Well, if I was innocent, I would wanna take the stand and tell everybody about it."
well,
Well,
you know
but
what?
if I had solved a crime, I would wanna tell everybody exactly how I solved it and here's what happened, because on top of that, the way we learn about how to prevent crimes is by learning
Oh my
from.
God, I got it off. Stop. Hold on for a
Oh, good,
second.
you
Can
did
we
it.
just recognize?
She figured it out.
Thank you,
Congratulations.
Fig.
Oh, there we go.
PTL, PTL. My God, I was going nuts.
That's too funny.
Sorry. Okay.
It's okay. I don't even remember what I was saying.
Neither do I. I don't care because you know what? Here we are. And welcome aboard.
Yeah. Hello, everybody.
Hi.
We're starting
That's
now.
now. And
Now that Andy can
hi.
think
Hi,
straight.
everybody.
There's certain things that I can't think straight until I either
Oh
move
my
on or
God.
teach it, but yeah,
No,
I
it's
feel ya.
oh my God. It's like the yeah, no. So let's do this. So yeah, but I do think that so what I'd like to do is just sort of saying for the royal we is that just I really want this to be focused. Everybody can bullshit and are welcome to comment. That's totally great. Welcome it. What is not acceptable is any sort of hate speech. I will not tolerate it. And thine shall be yeeted with the swiftness of an Arca potato cannon. Okay. So,
You
so
better
I just,
hope she eats you before I dunk on you.
but I want to pull up. So all that being said, we're going to go through motion to correct error, and then go back and forth and toggle back and forth. And I want people to put like drop questions or anything like that you have. And all eyes are going to do this to you. Some stuff that were flagged to pull up um, other pieces of kind of the puzzle here for um, the filand and stuff. So let me make sure that I have the right. This is actually the static image. One moment, please. There we go. So now this is my marked up version. Hey everybody. Oh look. Aw. Aw. Hello. Now this is fine. This I will take. That's totally fine. That kind of hate speech is fine. All right, but do try to be I need to try to focus.
Woman,
So
indeed, you
anyway.
behave.
Right, exactly. Please.
Be nice to your sister.
Oh my God. Um, so I went through, and this is just the copy and the paste version of the motion to correct error. And while I say going through line by line, yeah, we will, but I'm also going to shortcut it to the timeline that all eyes put together, and I'll bring that up here in a minute. But I just kind of wanted to reground everybody where we're at, right? So this was filed on 120. Is that right? 120, 2025. So again, this is that sort of period because the sentencing hearing was in December. Is that correct? I think
December
that's right.
20th.
Okay. So it was sort of like that. that month that sort of got lost. And I think that that is a byproduct of two things. People were just glad to have it over because it was such a mess. I'm sure the families were happy, but there was also the holidays. There were also all of that stuff happened, and all of this got kind of swept away.
Yeah,
Um, I think. I mean, it
a
sort of
lot
fell
did.
out of, yeah. So I just wanted to pull that back up. There was a motion to correct error. There was the state's response, which was ridiculous and an abomination to language, as I've mentioned. Nick can't write. But then there was a motion to strike, which was snark filled, fact filled, but on point. And then there was also the motion to reconsider that Andy Baldwin um, filed. So those are the kind of documents that I want to go through, but we'll start here as a jumping off point. So I think everybody here has got a pretty good grasp of what the situation is. With we don't have to do any sort of background on it. We can just jump into this, right?
Yeah,
Okay.
I think everybody here probably does. But if they have any
Yeah.
questions or if it's been a while and they just need a refresher, just drop it in the
Yeah.
chat and we'll try to catch it.
The one thing I'll point out is motion to correct error, from my understanding, is that this is something that is unique to Indiana and that it's been portrayed by some to be a sort of an illegitimate tool, and that's not true. So I don't know if you've heard people saying this is just the defense trying to do clean up after whatever. It's like, yeah, that's called the legal system, sirs, ma'ams. This is not an illegit. Have you heard that? I've seen people talk about that.
I've seen variations of it, and now
Mhm,
they're just trying to throw anything to see what sticks.
mhm.
But ultimately, it's a process that was put in place for a reason.
Correct. And it was because, there were, as we go through this, so I mean, the way that it starts out is going through the obvious or the seemingly obvious arguments to make from a constitutional law perspective, and like the Sixth, 14th Amendment, but it also goes through to detail and capture what came up at the end of the trial. Like, everybody remembers the old surprise testimony by Brad Weber.
Hmm.
That's considered new information because that was a new wrinkle in he had not testified that way before. Those things count as new, and I'm using this in the very broad sense, discovery, right? It's not literal discovery, but for the case of the motion to correct errors, for moving forward, it's a new piece of evidence.
Newly
Um,
discoverable evidence,
yep,
maybe.
yeah, newly discoverable evidence. So, and that was one thing that came out. So that went right into the motion to correct error. So it's a fail safe. This is one of the fail safes, and it's actually a lovely document to refer to. So comes now. Okay, Richard Allen. By counsel verified motion to correct errors for the reasons that follow. And I just did some highlighting. Y'all don't have to care about it. It's more for me, but if you enjoy it, enjoy it. Um, for the reasons that follow, the court should either vacate Mr. Allen's convictions or set the matters below for a hearing. So, Carroll County Circuit Court of Carroll County, Indiana, in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding. Now that's in quotes. Safekeeping proceeding of November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel. And under United States v. Chronic and its progeny, the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. Now, I think we should take a moment and talk about chronic and what that means. And it is so I'm trying to think if I have a good demonstrative other than just this. So the chronic case took place in the Seventh Circuit, which is like Wisconsin, I think. It's Wisconsin, basically the upper Midwest.
It's
And it was,
Indiana is included in that circuit.
yes, right, which is kind of why that is something that's great to cite to. There's been recent chronic cases, critical stages, and I'm sure people have heard like Bob and Andrea and all these other people explain it. So I'm not going to try to be real good at it, but essentially it's that at a critical stage. So if at a certain point during your arrest, pretrial detention, etc., you were deprived of your constitutional right to counsel, to the right to uh, confrontation clause, that is a fundamental violation and reversible error, and that's just as much of a constitutional protection as the right to remain silent, or Second Amendment, which is one of my favorites. And so it's significant enough that the courts came out and said, look, we are constitutionally bound to throw out this case. And the defendant's last name was Chronic, not Chronic, but Chronic, CR. And that was in Seventh Circuit. That was later affirmed, I believe, maybe 2 years ago, um, in another Seventh Circuit case where it was deemed the safekeeping, not safekeeping, a critical hearing, or a critical stage, was a lineup, and it was in, I can't remember the last name. It's Garcia, I think, was the defendant. And again, there the court found that at a lineup that was deemed a critical phase. So I think that there's a lot of hemming and hawing about whether or not the safekeeping proceeding, or if it was a hearing. There's a lot of semantics, and I think that makes sense because legal language is, it's all semanticy. But I think that the larger point is the constitutional one.
Well,
And
also my issue with this
Mhm,
and the semantics is I didn't know that there was a statute that said if the only issue is a defendant's personal safety, they have the right to object.
mhm,
And there's a post-transfer hearing. How
mhm,
is the defendant supposed to know that if he doesn't have counsel? So
mhm,
it's not even just one proceeding, it kind of ends up it's not just missing one critical stage. That's, to me, in my mind, that's actually two
mhm.
critical stages. And that's why it is so important, because he didn't even have the counsel to inform him or tell him.
Right. Right. Well, I'm going to pull up your timeline, because this is, there's a lot of weeds here. And I think that this is where you and I first talked about wanting to get into them, their weeds. Hang on a second. There's a very lovely timeline. Okay. So All Eyes did the Lord's work out here by pulling everything, the timeline, out of the motion to correct error. And so this, like, first, let me see where we got here, through basically page, oh, there she goes. Okay. Got Chronic down there. So this is from motion to correct error. As you can see, she's on top of it, motion to correct error. So he was booked, right? We know this. We've all seen the video, seen Sergio go through it. Um, and that was the 26th, 27th. Now I want to talk about this a little bit, because you brought this up about the attorney being hired, and I know that there were concerns around it, and there's some questions that you get about um about this. We talked about it the other day. Was this the part that we were?
Well, the questions are mostly, even if counsel was hired, because of the
Mhm,
ridiculous nature of how the county was handling it from start to finish, from booking him to moving
Hmm.
him to hearings in secret. It's hard to know what to do with these letters and whether or not counsel was hired when nobody even knows how and when he was informed of this. How,
If he
how
was,
yeah,
yeah,
that basically that, because there's not a lot to go on. So yeah,
right.
that's kind of my question about. We now know at the time there was a time where I didn't know about the attorney, and I didn't know the date, and I feel like we still don't know what date he actually wrote that handwritten letter. We're
Hmm.
still kind of stuck with all we know is it was postmarked by a certain date. But that, yeah,
Yeah.
that's essentially the questions I get are the nuances of, okay, well he did have one. Well, did he know? Did he not? There's still unanswered questions within all of this.
Hmm. So I'm making some notes here because I think this is exactly what one of the things we wanted to address. So he did. We know that he was booked into eh, that he was well.
Jerry Holman took him in handcuffs at the
Yeah.
Lafayette Post and then drove him to
Uh-huh.
Carroll County Jail, and he was
Under a
booked it.
pseudonym.
That's according to Nick.
Hmm.
I
Hmm.
still have questions about that, but
We'll put a pin in that.
according to the prosecutor, he was.
Right. And then the thing is, but the point is though, the next day, right? Let me try to move my little note thing. So there was an attorney hired, right? We know Kathy hired an attorney, and we know it because we have the receipts. And I'm trying to not go back and forth just yet. So let me talk through a few things, and then we can go through these first few exhibits that you put in here. We know that there was counsel had been retained. There's a $5,000 receipt, and we have that. We'll pull that up in a second. It's all in the record if you could get access to it. Sorry, I'm not trying to be funny, but it's if you don't laugh, cry. Um, this was hired on Brett Gibson, and Mr. Gibson sent a letter via email to the sheriff's office and to Nick McClellan. Okay, now we know that. We know that happened because we have copies of it. Lesnby confirmed receipt of Mr. Gibson's letter by telephone on the evening of October 27th. Now, this does all go to chronic, so I want to make sure everybody, we're still, this is the chronic phase. So these are all the points we had to go through. Sheriff Lesnby confirmed receipt of the letter by telephone. However, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. And we know that's allegedly because of this pseudonym. Then Gibson reached out to McClellan by email. Then McClellan called Gibson on his cell phone. Now, this is again, there were, I believe, and maybe you know this off the top of your head, I believe there were, in addition to the emails and everything, there were sworn affidavits to this effect from Mr. Gibson, I
I
think.
believe so. I'm
Yeah.
pulling it up real quick while you're going through it.
Yeah. I mean, I think there was, but I just it wouldn't be in the motion of correct error if there weren't. Um, Sent to Carroll County. So then he went to the Carroll County Jail, where someone, and apparently he doesn't know who, took him to a meeting room. And according to Mr. Gibson, the regular jail staff did not know that he was there. Mr. Allen was there. So this, for some reason, I need to highlight that because I need to come back to that. In the evening, so still on the evening of the 27th, Mr. Gibson met with Mr. Allen, advised him not to discuss his case. Okay, so we're on the 27th. Not to discuss the case over the telephone because calls would certainly be recorded. About 10 p.m., October 27th, 2022, Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. I want to stop right here for a minute. Some people now, and maybe this is just me, but I seem to have a memory of folks saying that, well, that's when that he was no longer representing him at that point. And that's not what this is. So this is not when he sent the letter saying that he was going to not no longer be able to um, represent Mr. Allen. This is just what it says it is. It says he contacted Mrs. Allen to let her know that. So still represented, right? This is another. We get to the 28th without Mr. Gibson. Okay. Now, what I can tell you from my conversations, um, going back a ways about this initial hearing is that initial hearings um, can, and somebody needs to correct me if I'm wrong. Actually, I don't know if I want to say that because I don't know if initial hearings are always considered critical because I don't know if they're always critical because sometimes it's just walking in, entering a plea, and leaving because he wasn't going to be set bail, I think. Um,
Diener set bail for $20 gazillion.
right.
It was
So,
an astronomical amount, which is ridiculous.
right. Um, so, uh, so I don't. So when that is brought up, when it's like, well, Gibson wasn't at this hearing, I don't. I think it was the kind of thing where in talking to like Kara and Michael and people that will know should know that that one wasn't, it's the safekeeping that was the one that was so concerning. Because this is more of a rote phase, I guess. I don't know. But again, that's just me pulling up some crazy ass information I had in a conversation. Take it for what you will. Um, October 28th, without, okay. So this was that initial hearing. Um, and let me get up to this point here. Now, is everybody with us? So we're up through, that's 48 hours. We have lawyer, we have in jail, retained. We have our initial hearing on the 28th. He pled not guilty. Everybody with us?
I'm with you.
Okay.
I found
Because we're
Toby's
gonna,
affidavit, by the way. That's why I was quiet.
oh, Tobe. Oh boy. Okay. So then I'm going to go through, I'm going to highlight this here and then we're going to pull up our little exhibity and we'll talk about it. Um, so again, we're still in the first few days, November 1st, 2022. Okay. Shortly after his initial, sorry, let me back up. Shortly after his initial hearing on the 28th, Mr. Allen was whisked away from the Carroll County Jail. I still think he might have been at White County, but that's just me. Yeah, to the White County Jail without a safe. Oh, I see what you're doing here. Got it. Sorry, that's
Yeah.
all eyes. Um, so he was then transferred to the White County Jail on the 28th. And again, this is just us spitballing because there are no records of this, right? We don't have like any. There were no transfer orders at this point.
Not that I'm aware of. I just went through all
Mm-hmm.
of the various media reports to
Mm-hmm.
kind of zero in on it in conjunction with what we do have in the record. And there were people, there were reporters walking around Carroll County, walking up to the clerk's office, up to the sheriff's office, like physically walking there on the 28th because people had been told something big was coming and they were there.
Mm-hmm.
No, people were saying nobody's here. The court was, nobody was there for court. Like when they went to the courthouse where this should have taken place, it was already done and over. And it appears that as soon as this initial hearing was over, he was transferred then to the White County Jail, and he stayed there until November 3rd, is what it appears from what we know. If there's anything different than that, we don't
Right.
know, but it's not, that is mostly from just people in person on TV, like different news
Mm-hmm.
reporters filming themselves walking through downtown Delphi trying to figure it out.
Right. Um, Yeah, so Indy Cindy, yeah, like I said, take take what you want from me. I think that from where I think I mean, to me, every stage is critical, but I think from the chronic perspective, and I don't know. I'm not a lawyer. I just attended 1 year of stupid foreign law school. So,
They entered the plea for him, by the way, or at least that's what Diener
yeah,
said. A
yeah,
plea of not guilty was entered for him.
was entered for him. So, and that could have been, and see, that's the other thing too, is like, we don't know if that was something that Mr. Gibson, we like, there's a certain amount of potential attorney-client privilege that have been going on behind the scenes. Um, uh, so I think that that's it. So yeah. Um, hang on. I'm just making sure because I probably shouldn't have said that. Um, no, I get it. So, like I said, I'm hearing you. I'm just saying that from a chronic perspective, I believe that was my understanding. And chronic is funny because they don't even know if safekeeping, and this is if the safekeeping hearing will be considered critical. So it's hard to say what's going to be held as critical if they do get to the point of even being able to file a chronic. Remember, keep in mind the best way to go about this is to get to the actual innocence of the matter, right? So appeals, even though the relative swiftness of Indiana appeals courts can still drag on. Post conviction, drag on. None of them are a sure shot. And so I think that that's one of the really important reasons that people like Amy did a live earlier that are really trying to go back through. And again, I'm not plugging anybody or any of that. I'm just saying that actual innocence and people going through the evidence that people have access to is more important, is most important, because none of the legal maneuvers are necessarily a given. I mean, clearly he's in prison, right?
Yeah.
So, um, so anyway, so then he was, you said, and you mentioned this too, that you weren't sure about if he was at the, let's see, should we go back and pull something up? So why don't we just review? So
Yeah.
here he hired an attorney. So, and people have probably seen some of this, but, oh well. Uh, mm, this is just some of the, um, sharing my screen.
Amy asked, there was a critical issue at the initial hearing. Oh, that is why Stacy requested the transcript. No, we're not
No,
actually positive that that is what she requested, or at least I'm not. All I know is that is the only thing that was not included in the clerk's record that was posted. I
right.
assume that is why she asked for it, is because it is part of the record and it wasn't included. There could
Hmm.
be some issues there, but as far as
Hmm.
we know, it's not to discount that there could be something, but as far
Right.
as we know, the reason for it is because it wasn't included.
But that's a great question though.
Yeah.
And so I think that that was something that I clarified with my inside crazy Indiana lawyers who would know, Kara and Michael, it's just what all I said. For some reason um, that wasn't in the court record or in the appellate record for some reason. But why would it be, right? I mean, everything else has gone swimmingly. Um, um, so you don't believe Gibson advised of a hearing? Advised who? Sorry. Um, advised.
Well, that's one of the things that we've talked about because we're like, well,
Yeah.
did he know if he called
Right.
Kathy to tell her? Does that imply that there was one? And even if it
Hmm.
does that mean there actually was one? Because nothing
Hmm.
was entered on the record until after it was over. And so it's one of those
Yeah.
things where we don't know. Like we
Yeah.
know what we we can make some educated guesses, but we don't actually know. because none of
Right.
this tells us. But it is we would like to know.
Yeah,
At
exactly.
this point, we
And
just don't, though.
so I think, and maybe, and this is actually a good point. Uh, let's see. Yeah, I mean, exactly. But, not everybody has a lawyer at an initial hearing, though. I mean, there are people that, and usually on a double murder, one would think that Judge Diener would have had the wherewithal to do it right, but no, he didn't. So,
He's a
um,
mess in general.
he's
He's
a,
a mess.
oh, well, I mean, yeah, he, it's a piece of work. I think that he's got some serious time on the stand. Come and listen. Um, but uh, so I think that Amy's question was a good one though, because that could, I mean, they could be tearing that apart because all we have, if I'm remembering this correctly, is the that where is it? You have it in here, I think, the transcript from the initial hearing. It's not even really a transcript.
It's pretty short.
Yeah, let me pull that up. Um, and I honestly can't remember. And maybe we can kind of sit and think this out. Does anybody have a recollection, and you probably best as anybody, as to what was brought up at did the going back through the like the trial? Do we remember any of the pretrial hearings where this was brought up in any way, or was that just at the, do you have
Where
any
which
recollection?
thing was brought up?
This initial hearing.
Not that I'm aware of, other than, like, we have the November 22nd,
Yeah, the
and I
Rosie
think
thing.
there might be a mention that it occurred in the sense that I'm Judge Cole, kind of like, "Wait, this is
Right,
now," like, I think there was mentions of it, but not any actual meaningful. I can if I can look through it real quick, but not like, off the top of my head, that's what I remember. I don't know
right.
that there's anything else.
Well, and see, okay, so here's another thing too. So this was something else I need to make mention of. In Indiana, and I was told this last night, in Indiana, if you are representing yourself pro se, meaning um, that you are held, and I would have to look up the statute. I don't have it, but you're held to the same, I think it's in the, hang on, it's in the motion to correct error. That there's two prongs here. Uh, there's two things that right to the, having counsel present, but then you also in Indiana that a pro se litigant without a lawyer is held to the standard of representing themselves. Does this sound familiar from our conversation?
Yes.
Okay. And I'm trying to remember what that, let me pull it up. Hang on a second because I'm glad. Let's see. I think it's code pretrial detainees. Okay. It's code 35, Indiana code 35 33 11 1 and dash 2. Let me see if we can pull those up for a second here. Um, General
Are you talking
Assembly.
about the part, sorry, I was also I just skimmed the November hearing transcript. They only mentioned Nick's verified requests to prohibit public access. They didn't mention the actual initial hearing, and at least in the November one. But are you asking about where he says, finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent
Yes.
him. Indiana courts hold pro se litigants to the same standards as trained lawyers.
Yeah.
And
Can you slide that into my
yeah,
into the chat? Because I was trying to look for it here. Um,
it's case law. I'll keep reading, but I'll send this one to you real quick.
yeah, because it's 30, it's dash one and dash two of that code. I just,
Let me see. Actually, let me just copy and paste the link. It's on, actually, I don't know if it's easier for you. It's on page 6 of the motion to correct error. I don't know if that helps while I'm trying to
Maybe.
figure out the best way to send this.
Maybe.
It's Zavodnik versus Harper, and then Article
Mm.
1,
Oh,
13A is what I'm seeing. I don't see a statute yet.
hang on a second. Here we go. It's in the motion to correct error. I got it. Sorry.
Okay.
We're nothing if not professional. All right.
Okay.
Hang on. Let me put it up because I think this is from the actual motion to correct error. I want to start this one, Amy. I want to come back to that.
I don't know if this was answered yet, but Jamie asked if we know Gibson, the date that Gibson contacted the sheriff and Nick. It was on the 27th. He emailed them.
Right. Just to say that but not, was that the when he
He was
said,
emailing them to say, I've been retained to represent Mr.
yes.
Allen. If any
Hmm.
questioning is happening, it needs to stop. Please do not question
Hmm.
him. It
Hmm.
was very basic.
Yeah. So here's now I got it. I think it's up on screen. So yeah, this is in the motion to correct error. So um, here's the code. Govern safekeeping. So this is the parameters around. Now I know we're still in the initial hearing, but this goes to the issue of what a critical stage is and about what a pro se litigant is, etc. And about the fail safe, so to speak, of the post transfer hearing, because this gets into some of that too. And I'm not going to get into a lot of the weeds on the legal stuff because I don't know it, but I just want to read it. So transfers for personal safety or safety of others upon motion by the sheriff, prosecuting attorney, defendant or his counsel, attorney general, or the court, alleging that an inmate in county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others. The court shall determine, so not will, shall determine whether the inmate is in an imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or facility of the Department of Correction designated by the Commissioner of the Department as suitable for the confinement of the prisoner and provided that space is available. For the purposes of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. Then Indiana Code, that same code, subsection 2, governs safekeeping proceedings for pretrial detainees. Post-transfer hearing, right of an inmate to refuse transfer, and this is the critical part, is that he had the right to refuse this. An inmate or a receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. Now, that is the actual safekeeping rule, right, of Indiana Code. And what All Eyes was just saying was the pro se litigant. You were saying it was they should be held to the. Sorry, I cut you off.
That's okay. I was just
Um,
reading the part of the motion to correct error where it got into it.
mhm. What page is that on?
I think it was 6.
Okay. Okay.
Um,
Here we go.
6, and it goes into 7.
Okay. Yeah. Finally, Mr. Allen's own absence from safekeeping proceeding, yep, should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standard as trained lawyers. Zvodnik, Brady, Harper, right. Once, one consequence of this should be that the Sixth Amendment, Article 1, Section 13 of the Indiana, now this I like too, is that he hauls off and points at the Indiana Constitution too, which, it's always nice to bring Fed and state Constitution. Should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present to participate in. Now, that's also For some reason I missed that before. It's also in the Indiana. Okay, so the argument is that the Indiana and the feds have covered off on this. So that's two layers there. That's good. So
Real quick before you move too
yep,
far on, I
I'm
haven't
not.
put it in the folder yet, but on the note about like when it comes to chronic, what are critical stages? There's the
Mhm,
Sixth Amendment Center. I think it's like a foundation. It's like specifically for right to counsel kind of issues, but the way they evaluate whether or not, hang on, how did they word it? Here at the 6AC, this is how we evaluate a right to counsel systems using United States versus chronic. And it says presence of counsel at critical stages. The first factor that triggers a presumption of ineffectiveness is the absence of counsel for the
mhm,
accused at the quote critical stages of a case. Arraignments, plea negotiations, and sentencing hearings, for example, are all critical stages of a case. If counsel is not present at every one of these critical stages, an actual denial of counsel occurs. But those were just, including but not
mhm,
limited to. But
mhm,
even something like an arraignment.
mhm.
So
But
I would assume a safekeeping, even if it's not specifically rolled on yet anywhere, I guess. It
yeah,
it seems
and that's the thing. It's the case that so I think that um
it should be widely recognized as a
I
critical stage
I would think so.
by all
But
metrics, I guess.
yeah, yeah, but that doesn't mean that the courts are gonna
Right.
do it, which is the problem. But you think about it's like when I think about I try not to slip myself into Nick McClellan's shoes or into the state of Indiana's shoes. But if you think of the most like candy ass way to get out of wrongfully convicting somebody, it would be to say, oh, it was a this is a critical stage issue. We're not so then they don't have to look into how bad the judge was. They could just say, I mean, it's like a bit of a parachute.
Yeah.
If there was any sort of compunction on the part of the state to think that any of those folks were in jeopardy of getting, you know, in trouble, which
I
of
don't think
course
they're
they
really
aren't.
used to being
They
evaluated or challenged or looked at or any of that.
exactly.
And so
I
they didn't
know.
really put much thought into anything other than their own convenience, what they preferred. They were not factoring in whether or not due process was occurring or how things were done right. It was they're used to what they say goes.
Hmm. Yep. 100%. And that has been obvious. And that was, propped up by a judge who was just, I mean, uh, what was it? It's the Andrea's famous phrase. It's like I've seen some bad judging, but that was evil. I mean, I don't know if she said evil or she said that it was just she'd
Yeah.
never seen anything like it.
Yeah.
I mean, on the scale of people that watch trials, Judge Bev is like, you know, uh,
She a mess.
she a mess, but Gull, I mean, I don't know. Maybe they're neck and neck at this point, but I don't know. Gull is just a mess and awful. Um, so what the hell? What are we moving on to? How's everybody doing? Anyone? Anyone? I'm just trying to see.
I've gathered some questions that we kind of got to most of them. I've been copying and pasting them, but most of them are just initial hearings are considered critical because you find out your charges. Fed
Hmm.
says the initial hearing is one of the most critical.
Hmm.
And then there have been a few questions that we'll probably get to as we keep moving through about um, why was Gibson there and then no longer there, essentially. Like
Right.
what's
What
going on
happened?
there, kind of stuff. Yeah.
Well, and that's the other thing too. So Gibson, when I'm trying to go back to our timeline here, um, let me pull this, let me pull this down, go back to your timeline because um
That timeline is just what's in the motion to correct error, but I put it all
right,
together. It's just a
right.
condensed version of it.
And it's great. Um, let's see. I'm trying to pull it up because I want to talk about when he said he could no longer represent him.
I think the
When
date
Gibson,
was interesting because that was the date Richard
that's what
Allen
I'm
was
trying.
actually transferred,
Yeah,
and the same day that Diener recused and requested something else. And in my opinion, that should have prompted the prosecutor to alert the court either way and immediately alert the new court. Hey, this thing happened at a critical stage. There was a recusal. Should be your first order of business once you're appointed. Maybe look at this. And there was none of that though.
what? I'm kidding. No, of course not. But then that would have to assume that Nick McClellan has ethics, right? That
Yeah.
he and I don't think that. I mean, there's no doubt here that McClellan knew
Maybe.
that Gibson was there, that the safe, and even I'm talking about the safekeeping order was coming down. Or do you think that that was between um,
I go
Tobe
back
and
and forth on this
Diener?
because I do think that ISP was running the show with logistics, with plans, with intentions, with a lot, and Carroll County just kind of went along with it. I think that was a great source of tension between Tobe and ISP. I think a lot of things were put into place before Tobe was even informed. I know some people don't believe that, but I do.
Hmm.
And I just, I think
Okay, but
as
wait a minute.
up until the 3rd, I
Hmm.
think Holman did the arrest. He went in and was explaining everything away. We're gonna put him here, we're gonna do that, and everybody was just, ref you know, deferring to whatever Holman had set up because he's the one who brought him in, booked him, and then no information was allowed except for the fact that Nick was from the 28th on at least. I don't know if it started the 27th or the 28th.
Hmm.
He was telling everybody, ISP and Carroll County, don't talk to anybody, don't release anything, everything goes through me. And we
Right.
know that because of the formal complaint that was filed with ISP. And they were like, sorry, we couldn't. The
Oh, that's
prosecutor
right. Yeah.
wanted us, the prosecutor told us we couldn't. So,
Hmm.
like, at some point, Nick did definitely take over. But I think up until whatever point that was, Holman took him into custody, Holman booked him. I think it was ISP up until Nick was having to actually get the PCA, and he filed on the
Mm.
I would think it was the night of the 27th because that's when Gibson contacted Kathy Allen, and Nick on the 27th was filing, or at least it was dated. He didn't file it until the 28th, but it was
Right.
dated on the 27th. The charges, the request to seal it, and yeah,
Hmm. Um,
a lot happened on the 27th. It's hard to know which came first, though.
right. So, I mean, listen, I just want to take a little detour, lighten the mood for a minute,
Okay.
because I know people enjoy my visual representations. I want you to picture, if you will, that scene from Ghost, and y'all know which scene I'm talking about. You seen Ghost?
It's been a long time.
Girl, you know which one I'm talking about. It is the Demi is throwing herself a clay pot, and Patrick Swayze is all cozied up behind her. Do you not remember? Oh my
I
God.
have
Am I that
I have,
old?
like, vague you're not, I
Oh,
just haven't
no. Oh
I'm
God.
trying to think the last time I actually watched that is probably before the internet was even a thing. Like, I don't even think we had internet at home. It's
Oh
been, like, a lot.
my God.
I haven't seen it a bunch of
Oh,
times, but
okay.
it's been a
Thank
long
you. Thank you. Okay. Mar knows what I'm talking
time.
about. Okay.
Yeah, vaguely.
So just, I mean, just Patrick Swayze is topless and Demi Moore is wearing like his daytime high paying fancy, Wall Street job top, but she's throwing a pot on her thing at home. And he comes up behind her and gently embraces her from behind. And they make a clay pot, if you will. Now that's how I picture Diener and Tobe. I want you to I want you to think about it. I want you to think about
No, I'm
it.
rejecting it.
And it's like the Unchained Melody is playing.
Oh my gosh, Diener's so derpy looking. He's
Uh, The heart wants what the heart wants. Okay, sorry, I had to. Okay. Oh, gross. All right.
Diener always looks lost in all of his headshots. He just
Oh,
looks like he's looking like he's, like,
listen.
yeah.
Oh
"Have you seen my
God.
daughter?" I'm trying to
I
like, he's
mean,
trying to get
it's
home. His daughter's trying to, like, find him and walk him back home. "Come on, dad."
oh my God. But I always have this picture of him in that crazy ass thing where he's like bloodlust, bloodlust, and then he like stamped it and jumped out the back window of the courthouse and drove away. Like in my head, that's all I can see is him doing that crazy shit.
He's a little
Um,
baby. He just was like, "Oh my gosh, criticism, people looking at me." They're so unaccustomed to having to answer for anything that even mild scrutiny and just basic questions, like basic information requests. The media was making very basic requests and he panicked. It's not a
he
normal
jumped.
reaction, but he went
He
into the
jumped.
panic mode. Yeah.
He jumped out the back window of the courthouse.
That order that he entered was
It was
hysterical.
insane.
Like,
I
it's just
never.
bizarre and strange and embarrassing. I don't I don't understand how he actually filed that.
I don't
Somebody should have
either.
been around him to be like, "Sir, are sure, maybe let's edit this to make it sound less insane." I mean, he just
Well,
sounded Looney Tunes, to me.
Uh, yeah. I mean, I remember where I was the first time I read that. It's kind of like when Kennedy died or whatever. Pick your major life event, 9/11, all of that. When I first read Diener's, yeah, no, that's I was sitting here shell shocked at my desk, not believing that an actual judge did that.
Yeah.
Anyway, uh, all right, so keep that in mind as we move forward. Pottery scene, uh, Tobe and Judge Diener. Okay, so I think that there's a really good thing here that you brought up about that time period and how, and I think everybody's bringing it up, and in Cindy and some of these other folks are like, well, of course it's a critical hearing, of course this is a critical phase. And the truth is, we actually really don't know, except from the sort of paper trail of emails between Gibson. I mean, really, what we have is, I think, just the email between Gibson and Kathy Allen's sworn affidavit about when she was notified, but we really don't have any clear direction or understanding of the first, like, I would say 5 days. Do we?
We know
I
that
mean,
I mean,
really.
j like, the extent of what I know from what we have is Kathy after Holman booked Richard Allen into the county jail, Kathy retained an attorney on the next day.
Hmm.
That attorney emailed the sheriff and the prosecutor, and then
Right.
he called the jail, and the sheriff said, "I got your letter," and someone else and or the sheriff said, "But he's not here." And so he called the
Yep.
prosecutor called him back, and at that point, he said, "Well, he's under a pseudonym," and then he made arrangements for Gibson to go meet in person with Richard Allen, and he met with Richard Allen on the 27th at the
Hmm.
jail, and after he leaves, he contacts Kathy Allen and says he's gonna be charged tomorrow, and we
Hmm.
don't know anything about Gibson after that until the 3rd when he emails Nick McClelland to say, "I don't think I'm gonna be retained for this matter,"
Hmm.
to just let him know.
Hmm.
And then we never that's that's the end of him.
Hmm.
In between there, we have a letter that has been postmarked on the 1st that
Hmm.
doesn't get filed with the court until the 9th. And Judge Gohl, even though she's appointed, the order appointing her is on the 3rd,
Hmm.
and she does not do anything until the 14th, where she enters an order appointing counsel and setting a hearing for the 22nd.
Let me pull up
When it
because I
comes to the
think
Gibson side of things, that's the extent of what we know of him, where he entered, where he left, and the the very, very general context of it. Because Gull acts like the first thing she knew about the case was the letter. And I say acts like, I mean, the
mm-mm,
actions she took
mhm.
first, like I don't know, she didn't seem to even know about I don't know if the 14th was just the first day she did anything, even though she was appointed on the 3rd. Like, she didn't log into her email or something for Carroll County. Like, I don't know how that works. She was
Yeah.
appointed on the 3rd. And I guess maybe if she looked at the last thing on the 3rd, I don't
Here
know.
here's what I noticed about this. And um so I got the letter up, right? So this is, and I don't I'm not sure about the, I mean, and we see the letter was posted, right, on the 1st of November from um Monticello. So that's the White County Jail. So we do have him sending this on the 1st of November.
In the letter, he says, at my initial hearing. So we know it was after the initial hearing and before November 1st. And that
Hmm.
is as much as we can possibly narrow it down. It probably would not have been postmarked on the 1st if it hadn't been sent by the 31st of
Uh-huh.
October. So I would think it was either the 28th, 29th, 30th, 31st, depending on how long it takes to get to the post office to be postmarked.
Well,
From the,
that's just it, right? Yeah. Yeah. So, but here's the thing though. Wait. So the first is when it was postmarked though.
yeah. So I mean,
Okay.
it was obviously written before the first. Like, it couldn't have
Yeah.
been written on the first or after the first if it's being postmarked. But
Right.
because in the letter he states, at my initial hearing, I blah 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 blah.
Yeah. Yeah.
So it was written after that. We know. Well, I say we know. It appears that after the initial hearing in Carroll County, he was transferred to White County, so it would have been either later on the 28th,
Hmm.
sometime from that point prior to the 1st. That's
Yeah.
if
And
we're
then
getting real technical, that's as much as we can narrow it down.
here's the thing I find very interesting though about all of what's going on in this letter. When's the last time you looked at this envelope? Um,
Um, DB looked at it pretty close. That was the last time I looked at it.
because I do think I think it is interesting, and I think sometimes it's little stuff like this that I get caught up in my underwear with. But you see, it was received, or there's the franking down here at the bottom. There's the
Yeah.
11. So that seems to be when it was returned from. So it looks like it was. Let me see. County Jail. Clerk Carroll County Court, November 7th. And
That's when it
then,
was filed, yeah. The
yeah.
only excuse I have been able to find for a disregard of the prison mailbox rule or anything to do with what would cause a mail stop is a courtesy hold. If White County had only accepted him as a courtesy hold, they don't
Hmm.
receive or send mail on behalf of courtesy holds because they're not the custodian. I have no idea if that at all
Well,
has any bearing on this. It's just when I was trying to look for something, anything to indicate what could be a factor to see if it
mhm,
was even something we should look at harder. That was the only thing
right.
at all that I could find, and I don't even know that it would apply to this. I just beyond that, I have no explanation for why they would have put a mail stop on it.
Well, and the thing, I guess what I'm trying to figure out is that, and that actually is interesting because I don't know where in proximity the White County Jail is to Indianapolis or what the major post office hub is, but I mean, uh, you know, the town that's near where I'm from as a kid has 300 people, unless somebody dropped out and like died at the nursing home that day. And we have there's a franking machine there. So why did this one have to go through Indianapolis? I guess I don't get it unless that's the closest one.
On here, it says from Monticello to Indianapolis, it says 1 hour and 30 minutes, 89 miles. I just
Hmm.
Googled Monticello, Indiana to Indianapolis.
Because what I guess the thing is that it would make sense that it could have been a courtesy hold and somebody sent it later. Because I'm convinced he was already on
Courtesy
his
hold, but
way.
they don't even like even if he had tried to mail it, like
Hmm.
the people who collect the mail, or if he was there and he's like, "Here, I have a letter," and they tried to send it, the person might not have known the rules, so they would have taken
Hmm.
it and tried to send it, but the prison maybe or the jail
Hmm.
maybe. But that's what I mean by I wasn't sure if any of this
Hmm.
applies because I don't know. There's not a lot on it other than it is a thing that happens. There doesn't seem to be an actual administrative statute specifically about it. That's why I do tend to at least leave it on the back burner
Yeah,
because
for
there's a
sure.
gray area. And I'm like,
Hmm.
oh, that gray areas are that's where they live. At least like
Hmm.
the,
Hmm.
the sheriff and prosecutor. And so part of me wonders if it like until I know what to do with that, it's just on the back burner. That's really, I guess, the extent of it.
Yeah,
But yeah,
yeah. I
there's
was just
something about it where it could affect it, but who knows?
I was thinking about it from more of a timeline perspective, right? So
Yeah.
if we like sorting out where he might have been, because I don't, uh, I don't think that he was still anywhere near either of those counties by the time this got into the hands of
On the
the
3rd,
authority.
he was at Westville by the 3rd because
Yeah.
we have filings that cite DOC video of him
Hmm.
in his cell on the 3rd. They skipped him right past the reception diagnostic center. Normally, you're supposed to go there first,
Yep.
however many days.
Hmm.
They didn't even, I mean, they just bypassed it. And it appears that they just used Walla's office or wherever her
Oh God.
area is in there because it looks like because the first time Rozzy mentions it, he says it appears there was a stopover at RDC, and then in later filings, once they got more information from Westville, it almost seems like he had updated information. It's hard to know because he's never gone beyond the initial thing about RDC to it never happened. He was just bypassed. And so I don't know more than that. I think Rozzy probably included that because that is what normally happens.
Hmm.
And so they assumed these intake records from November 3rd would have been there. And then as time went on, it appears that it was just from Walla and Martin. And unless they drove out to the reception diagnostic center, like they were at Westville. So I'm like, I think all of this happened there, like on site. It's hard to
Hmm.
know though, but we do know he was at White County Jail until Westville.
Hmm.
And it's just this shit annoys me. Like
I
we shouldn't
know.
have to be like trying to decode and like do all this stuff.
Well, and see, this is just page two, right? Of the no, but I'm saying that but this is all part of establishing sort of this is all part of establishing from the way that the motion to correct error is put together,
Real quick,
you
Indy
know.
Cindy just said it was mailed from Indianapolis and then remailed from White County.
Mhm.
So like they sent it back to White County and then they from White County it was remailed from there, which is dumb, but that's appears
You
to
know
be what
what?
happened.
So, oh, that makes so, yep. Okay. Yeah, thank you. My God. Okay. I
I
wish
mean, I
I
think
had more.
I just keep like it's been a while since I've gone down the what happened to the envelope thing or like what does it say underneath this? What does the stamp under the stamp say?
Right. Well, and so anyone researched? No, but I did have a case of a very mysterious letter showing up almost 20 years after somebody died, but that's for another day. Um, but so yeah, that was just, but I think that that little exercise that we've just gone through is all contained in the explanation for the argument that could be put forward by Liliana and Lehman when and if they incorporate this into um, the the appeal, and you want to put all your stuff into the appeal, right? So all of this, and And that goes back to sort of one of the initial questions is why did she have to reach out for the transcript for that initial hearing? And I, I think, it's because nothing has been done appropriately, including making sure that a guy that's in prison for 130 years, appellate record is intact,
Yeah.
is, so it's all kinds of fuckery. Um, but yeah, so this is all falls under that same um, safekeeping, and including the mailbox rule that you brought up. And this goes, I mean, it lays out pretty clearly um, with exciting case law. Let's see. I'm just going through what was written in the case law. There's another thing too here that's interesting. And again, I'm just going to say one last thing about Judge Diener and his clay pots, but he had no jurisdiction to issue the safekeeping order, um, is what's being proposed in the motion to correct error. And I think that's probably true. It's just another, what am I trying to think of? Like, it's just one more thing to add to the pile to really drive home how, like, even like the here's a thought exercise, right? It's like, well, okay, so you mean to tell me that this goes to an appellate level, or even let's say the Seventh Circuit? It's one thing to have, and I'm not making excuses for this, it's one thing to say this guy wasn't allowed, didn't have counsel at safekeeping order, or wasn't served, or whatever the case may be. But when you see the timeline, just that first like 5 days to a week, that's I mean, there's actual evidence here in the record, on the letter, whatever, and the affidavits, but there's also just the timeline of how, just from the very beginning, this whole thing was a fucking mess. And so I think
Yeah,
that
the fact
bill
that he's
that
being evaluated by prison psychologists and being put under 24-hour surveillance
well,
and
we haven't even
solitary
gotten there
confinement,
yet.
he was they took more procedural steps to put
Mhm.
that in place and secure 24-hour surveillance in the event of future litigation. They were able to factor all of those things in by the 3rd, but they couldn't even hold a safekeeping hearing. That was too much to ask. Like, Diener couldn't do that one thing, but they were able to put all of these other things into place and coordinate with multiple jails and a facility and
Mhm.
transport. They did all that, but just the safekeeping hearing was just too much.
Right.
It just and during that time, they were planning a big press conference for the 31st.
Yeah. And that's, no small coincidence, right? I mean, it
Yeah.
all dovetails nicely. But, and the thing, so here's the other thing, and you and I were talking about this too. It's like, and I had this idea like, oh, is the state going to pull some filing out of their ass to say, oh no, we did actually serve X, Y, and Z. We did actually give Mr. Allen we did
Mick might
actually
cite it,
notice
but I doubt
him.
he'll put it forward just like the phone
But
battery thing. Like, he'll mention it, but then we'll never see where it came
oh,
from. That's what I'm
well,
worried about.
but the thing is that
He'd be
again,
like that.
the so that, um, but the thing is that, it's clear here that it's not filed, right? Because from the motion to correct error, it was not, there is no record. And so there it may be shoved behind,
Maybe it's in the
Nick's,
file cabinet drawer.
it's
Captain
probably in,
Shank looked for it.
it's a, or it's sitting right next to that other letter from Reese.
Mhm.
Um, but the point is, it's not in the record. And so the appellate, what, the state court, you and I talked about this too. It's like the state might be less inclined to do something because it's the state, which sucks. But, you know, the federal level doesn't care. The circuit doesn't care. So if there's not something in the record, like a being served with it will matter. If, if, if we can get it to that point before something terrible happens,
Yeah.
you know? And that's going to take some time, but it's not preserved within the record. And um, that's what's made clear in the motion to correct error. Um, and let me see here. I'm just going through my little notes. Yeah, here's another thing. Okay. Fourth. Um, so going back to Tobe, picture him, if you will, shirtless.
Gross.
Safekeeping. Ew. Um, his safekeeping request was not verified. Now, have you noticed this too when you're going back through um, uh, all of Nick's, like the response, the motion to strike, all this stuff that Nick filed? It was never verified. It wasn't uh, like a sworn affidavit. He just basically was like,
His
"Yeah, I did it."
requests to prohibit public access are always verified. All of
Yeah.
them are verified requests, but that's about it as far as I
Hmm.
know.
Hmm. Yeah, exactly. And but that's the thing. But this is another thing you and I spoke about. It's like what he does and does not do is telling. So he verifies those things that he really wants, right? He really wants to keep everybody out of his business,
Mhm.
even though it's public business. So that's got to be done right. But safekeeping orders, state response, the response to the motion to strike, all his harumping and nonsense is not only written terribly, but it's not verified. So his act and omission, he just tells on himself.
Yeah.
Like I would love to play poker with this guy. I really would,
I think
because
we
he's just,
learned more about what kind of defense attorney he was through all of this. Every time he talks about what he defense is just, even in his motions to the judge, he sounds like a younger brother tattling on his older, like saying all the things that he knows will trigger his mom to be mad at the brother. Like he says all these things. They're probably doing it for this reason. Every
mhm.
time he did that, or even in his interviews, I feel like he was telling us what kind of things he did and what he was up to. I think we
Yes.
definitely learned more about him and how he practiced and the things he would do than we learned about anybody else.
I mean, who
I mean,
maintains that kind of facial hair? I gotta, I'm serious. That was like that. I can't. I can't. I went to high school with jerks like him.
yeah.
um. Okay. So that's. I mean. So now he's a. So that's. Let me see what the chronic. Let's see. I'm going through, and this is page 2. Sorry. Um. Right to judge other than judge. Interesting. This gets into the weeds a bit on page 3. Lesenby transferred Mr. Allen to White County on October 28th with no say. So this is what you pointed out earlier, just sort of reiterating no safekeeping order in place. Next, he had no standing to make that request on the 3rd due to the fact that he had been illegally transferred. So, yeah, I mean, this is all again in the motion to correct error, and it's all bolstering. You would think that the safekeeping hearing would be enough, but this is all going toward that. This is all leaning into that because this is all the chain of events that led up to that.
Yeah.
And it's important. And it does lay out the letter in here too. Um, but let's see, factual finding. Yeah. And so somebody pointed this out earlier too about that a factual finding is required, right? And there was no factual finding.
Well, there was no
There's
proceeding.
right. There was no, finding, proceeding. There was vibes, I guess,
Hmm.
right?
I get. I mean, I don't know if you call being a scaredy cat vibes, but that was the reasoning. Was Diener got scaredy cat?
There was bloodlust. Do you not understand?
Yeah. Requests for information that
Hmm.
like related to the arrest that was just announced
That
is
you had
somehow
a press
bloodlust. Like
that
it's crazy to me. It's too stupid.
that you had a press conference for.
I
I
mean,
mean,
before the big press conference, there were media reports about it, and media
mhm.
like all of the ones that were at trial, WTHR, Wish TV, all of the ones that we all know, there's like a list of like 6 or 7 of them. All they had done was submit requests for the charging information and the PCA, because normally after an arrest, even if it was sealed before, usually it's made public after an arrest.
Of
In this
course.
case, they did it backwards. And there were some local judges even who gave statements to all of the local outlets saying it was very unusual and there must have been some um, very niche reason why, because it's so, it's not, it's absolutely backwards. But yeah, it's people were doing what they do in all cases when an arrest is announced. The media requests the charging information and the affidavit, and if they can't access the full thing or a redacted version, they ask for a publicly accessible version, because I'm pretty sure in all states you have to make the factual information about the person, the charges, very basic facts of the arrest, where they've been booked,
Of course.
public.
Yes.
And so even if you don't
That's
get all the details that you'd like, there's certain factual information they are required and mandated by law to release. The media was making very basic requests for that information, and Diener called it bloodlust.
yeah. Well, and the thing is that when I think about like public trials and access to justice, that means also for the public, because that's it. We are that system. And so even the simple um, uh, filings, like this is all part of it. It's not just who is allowed into and out of the courtroom. It's all of this is part of the public
Well, that
trial
is also
process.
part of the defendant's right to public proceedings and public trials. They
Yes.
have, since
Yes.
Anna 14th, absolute right to public proceedings that are scrutinized, and
Mm-hmm.
this man did not get that.
Mm-mm. Mm-mm. No, he did not. Um, oh, hang on a second here. Let me see. How are we just at page two?
Because we're getting in the weeds.
Right. Let's see. Let me take this down. Um, where do we want to go next? I'm trying to think. Let's look back through here. Mm-mm-mm, mm-mm. I'm looking at people's little questions, comments,
I think maybe
concern.
just a quick read through of the timeline, and then it'll jump. You can either go to the Chronic or the Napui stuff, but maybe just a quick review, since we did, because normally when these issues have come up about the lawyer and
Mm-hmm.
retained, it's always been in lives that were actually about something else, and it was
Mm,
something that either was new, and so we've actually kind of gone into the weeds on when she knew, was there a meeting, did he know, like we kind of covered
mm-hmm.
that. Where with some of the stuff, all we can do is a best we can tell. He knew there were charges. We don't know if that implies that he knew there was a hearing. Like, we've covered all that, but if we just go back through the timeline up until the 3rd, then we can kind of go into the issues that falls into, now that we don't have to stop and explain why that's important or why it's a critical
Mm-hmm.
stage.
Mm-hmm. Um, yeah. Okay. So let me just see here. So yeah, so we're at you go through the prison mailbox roll. Let me just see here. Boop, boop, boop. Yeah, went through that. Diener had engaged in ex parte, and this is another thing. We haven't talked about the ex parte. See, this is where I imagine the scene from Ghost comes in.
Well, we did a little, but it's because I don't know what to make of that. That is one of the things I go back and forth on. They obviously, there was some communication, because transport orders, you can't just transfer an inmate without communicating with somebody. So
Well, it's
obviously there was some communication, but I just feel
I
like
know.
it was not limited, I guess, is my question, or not my question, my concern. I don't think it was just the sheriff and the judge. I don't
No.
think ISP was part of it, I guess, is probably the best way to put it.
Yeah. Yeah. So I think it sounds like, I mean, Diener violated. I mean, this is a huge no-no. Like, this is not, I mean, he violated the rule,
Yeah.
rule two. But I think what you're struggling with is trying to confine it to two people, and I'm saying don't. It's
Yeah.
all of them. I mean, I think
I don't
that's
know that they were, but I don't know how they couldn't have been because even the press
yeah.
conference, it was
Mhm,
everything was
mhm,
planned as a little group effort, and they were all there, they were all in communication, they were all briefing each other. There was intertwined communication in general, and it just for me, I think it would be strange if they just didn't at least read ISP in.
mhm.
So, but that is even more agencies that are then violating some sort of rule or statute, and I think that's
Well,
the only reason I bring it up every time is because I don't think it was just Carroll County up to no
right.
good.
Well, I'm sure it wasn't. I think that this is the floor, not the ceiling when it comes to
Yeah,
what Diener got up to, I think. But I think the point is that this needed to come from law enforcement and not cross over this threshold, right?
so
That exists for a reason. Um, and that's the procedural rules and sort of this tertiary law that seems like minutia, but again, it stacks up and it is a thing. And it can't be, it can't be, explained away, or people try to make it less than it is, because when you see the totality of it, what the fuck, man? I mean,
I
Jesus,
do think
what?
there's something to the public access order that or opinion because they can issue
Mhm.
pithy opinions, but not orders that are enforceable.
Right.
So they're just annoying. But the opinion that was issued in 2023, I do think they made a good point that a lot of this seems to have been done for optics, and
Hmm.
the October 31st press conference and everything was kind of scheduled around that because they wanted to do it on their terms, on their timeline. They didn't care about, of course, they found that there was no, the only reason I question the pseudonym thing is because this order, or sorry, I keep saying order, this opinion found that ISP violated the law by not even creating a record.
Hmm.
So that would include the pseudonym, in my opinion, but I only bring it up because it allows me to bring up the order too that they did violate the law either way. Whether it was a pseudonym
Well,
or not, they violated the law. They were found to have violated it, and it was all for the sake of a big press conference that at the same time they're going before first Judge Diener and then in a few weeks Judge Gold to say we don't want anything happening in the public opinion or in the we don't want to play anything out in the public. We don't want to
mhm.
prejudice this man. And that's the reason we want to seal this information, even though we did all this designed around a press conference to set the narrative.
Yeah, 100%. Now, I think that there was another, um,
They could
I
not
think
have
there
been
was,
less concerned about due process or not prejudicing him. It was
oh,
all
please.
about Nick's press conference.
Yep. Yep. And, but I think that there was also, I believe there were two, was it just one or was it two, the public, what is it called? You just said it,
The
the
for
public.
the opinion on the formal complaint,
Yes. Wasn't
Ron
there
Wilkins filed it
two?
on well, they said this was held in abeyance of other orders being issued. I have to this day not been able to find out if that was orders that Goal wrote or other
Mm,
I don't know what it was
mhm,
referencing
mhm,
because
mhm,
that was issued on February 10th, and
mhm,
there were a couple of orders in January, and then there was a couple after that was issued. So I don't know what orders they're referencing in that opinion. I've tried
mhm.
asking, I've tried looking. I don't know what it is. I don't know what they're talking about.
Um,
I've asked and I've looked though.
I'm trying to think of, because I'm trying to think if there was another one filed, but I'm trying to remember if there was another opinion that came down about ISP in this case in particular, or if I'm making that up, or if there were
I
two or
think it
just
might just
one.
be there was just the one opinion,
Okay.
but there was a response from ISP about the formal complaint before.
Oh, right. Okay.
Yeah, so it could have just been those because the opinion is basically just restating what's in the ISP reply. So
Hmm.
they're kind of the same thing, but it just essentially explains all that and then says, yeah, they violated the law. Or opinion issued. Like
Right.
they're just confirming, yeah, they violated the law by not creating a record, but there was one aspect that was moot by the time he filed his formal complaint, him
Hmm.
being Ron Wilkins.
Yeah. Yeah.
I always forget if it's Wilkins or Wilkinson, but Ron, whatever. Um, he filed the complaint after the fact, and because ISP had already held a press conference and issued a
Hmm.
press release, they said, well, even they did violate the law, but the thing you're requesting you already have, even though I don't think that was appropriate. The arrest log, the actual information was not put out. It was just a press release stating certain information through the ISP like email press release, their auto generated thing where they put it out and anybody subscribed can get it. Um, According
Hmm.
to that formal complaint, Diener took the arrest log, which is not a judicial record, as his personal work product to keep it confidential throughout all of this. And I,
Okay.
to this day, still don't know if if he forwarded that to Goal and it became part of her work product or if it just disappeared. I do not know. I don't even know if it matters. I just know that it bothers me.
Well, it's infuriating. I
Yeah.
mean, it's just it's abuse of power in the worst way. So I'm picking up and I'm moving across here. Hang on a second here. I'm walking. Um, so let me just see. I'm walking into my other room. It is so I'm gonna have like maybe 20 more minutes. And then I gotta jump off.
Okay.
What do you want to try to what do we want to try to chat about at this stage? And do we want to try to like, do you think that this is a productive thing? I guess let's talk about that. Do we think that this is a productive thing to do?
I think it's
Or,
productive to remind people what the first thing was after sentencing and where we're headed, and trying to
Mhm,
just get on the same page about where the record stands with new information and the issues that are being
mhm,
looked at. And I do think that's productive because
mhm.
I care about it.
Well,
I
I
don't know if
think,
it is productive for others, but for me, I feel like it is because we
yeah,
can ask these questions and then kind of, even with chat, like
yeah.
get into
Well,
the semantics of some of it. But yeah, at this point, I guess I don't. I guess that's up to you, really.
Well, I mean, I think it is, and here's why, because it matters, right? And because there has been such absolute bullshit
Yeah.
going on, and it's like, you know what? I care very little of people's opinions of personalities, whatever. I really don't. What I do care about is when personalities take over the uh the what's at hand. And like I've never seen anything like this particular case. Now granted, there's bad the legal system, it's the criminal, the carceral state is a hell of a thing. But the fact that so many personalities get caught up in their own underwear and detract from
Yeah.
what is but this is one thing that we are in, like people are in the process right now of this moving forward. And
Mhm.
there's enough people that are interested and invested and have been doing this. I mean, you've been at this, folks have been at this for a hell of a lot longer than I have. But you know, it's right here in front and center.
Well, I
And
do think it's
time's a
good, like,
ticket.
periodically to kind of regather and refocus because even I try to, even when I can't actually catch someone else's live, just for, like, the view, like, I'll put it on my computer and make sure it's playing just for, like,
Yes.
for me and my but I don't always actually get to catch it. I don't see everyone's post. I don't see a lot of it, and so it is good for us to have periodic check-ins because for some people, even me, I try to keep up with stuff, I still miss things, and so
Hmm.
even just on that level, I think it is good to kind of recheck in, especially when because we're at a part of this where there's gonna be lulls, and
Hmm. Yes.
a lot of times when there's a lull, it's hard to keep track of where it left off last, and So this is good to kind of put back in the forefront what issues are at hand and why they are important, and why it was not like, even when I was listening to the juror interview, there were things that were, oh, well, during pretrial, Gull actually tried to hear all of this stuff and she just decided it wasn't important, so it was left out. Well,
Wait a
actually, this
second.
could be an issue that's coming up, and it wasn't as simple as that. So it is good to kind of re-dig into them, into
Oh,
the actual
mhm.
issues, because that's not true. I mean, she did make that decision, that part is true, but the notion that there was some sort of hearing and all of this was weighed carefully is absolutely not true.
It's oh my God. I mean, here's and I've said this from when I first stepped my toe in this whatever shit show, is that I don't, you know, I don't care what anybody thinks about guilt or innocence.
Mhm.
This is, I mean, I don't know if people have noticed, but the actual rule of law as an ideal is very tenuous right now.
Yeah.
And it literally could be anybody,
Mhm.
any one of us, I think, in the United States now more than ever.
And what are you
Um,
gonna do if it happens to you and nobody's coming for you and everybody's just making excuses for that judge and the people who kidnapped you? I
well,
mean, it's happening to veterans, to citizens right now, like,
yes,
across
yes,
everywhere. This is an
yes,
actual issue, and it is important, and a lot of people don't care because they think it's only happening to either people who actually probably were the right guy or people who probably weren't documented. And that's not the case. When you actually
right.
look at all of these cases, you're finding out how often that is absolutely not true. It is important, even if you think he's guilty, especially if you think he's guilty,
Yes,
make
yes.
sure that that we do go through this and we do check it all off, because a lot of people have this notion that defense attorneys are just dirtbags trying to make excuses to get people who, like, they're lying for guilty people for, even though they know they're guilty or whatever. That's not
Hmm.
true. Their role is to ensure due process was conducted, that the charges actually fit the crime, that
Right.
steps were not missed. And a lot of people think they're looking for loopholes. Their actual function is to make sure all of those have been patched up before proceeding, to make sure that we do get it's part of the process of getting the right person, and it's part of the process of giving families closure, because then if the person does appeal, which we still have that right as another fail-safe because we don't always get it right, they can appeal, but when you have all these things to point to that it was done, they can at least tune it out, like the victims or
Yeah.
families, and it can just be something that we do as a society because it's the right thing to do, to have these fail safes and to make sure and to always leave room for making sure we got it right and fixing it if we didn't. But these people are just glossing over it because they think, well, he's guilty, so I don't care if it happened to him or not. He deserved it. That happens
Yeah.
too often, and it shouldn't even be about that. It should be about what we do as a society. Like, if you don't have time to do it right the first time, when are you gonna have time to go back and fix it?
Hmm.
In addition
Hmm.
to, you can't just like this could be your husband, your son, your brother. We,
Well,
like,
yeah.
it's just one of those things where you have to care because it's the right thing to do. Just, I guess, is
Well,
probably the best way to put it.
well, and the thing is that it's taken for granted, and frankly, the way that the prosecution or the state, the power of the state, let's just put it that way, any
Yeah,
state, pick your state, um, it has come to bear uh, on the most basic of rights ain't no joke. And this is not like guessing.
yeah,
This is straight up founding documents, folks. And it's not like some bullshit made up stuff. This is allegedly, what our country was supposed to have been founded on, and I use founded in air quotes, but you know what
yeah,
I mean. So the trust something and stuff, the rule of law, at least the ideal of it, is what is happening right here. And you can think that, it's really hard to be in favor of a fair trial for a person you might think, or I might think, murdered children. Trust me, I get it. I get, that there are some disgusting people out there, not even just murder, right? We can
Yeah.
all think of terrible shit, but I don't presume to want anybody. Everybody deserves the fundamental rights that are afforded before the law. They simply do. The power of the state is too strong, and uh, it we're at, I don't know. I've given up on
Well, without
hiding.
it, a good way to look at it too is imagine all of the accusations that are made against people on the internet
Oh,
based
yep.
on very little evidence. If it
Hmm.
Imagine if some of those people had badges. Do you think you'd be getting due process? Like there's a reason we have these very clear and established procedures and laws to do things because anybody can succumb to just he looks guilty, he probably is the right guy. Why even bother looking? We have
Right.
to because whether they're people on the internet, and in some cases these people have um like in some cases they are professionals, in some cases they're just people. But a lot of law enforcement officers before they had their badge, they didn't have many other experiences. It was, they just went from regular person to having a badge very quickly.
Hmm.
And all they have to go on is their professional experience and judgment, and it's based on a very limited frame of reference for what happens, and it's only pertains to what they've seen, and it does not factor in all these other things. And so there's a reason why we need to have a widespread, very established way to do things, because it is easy for all of us to get stuck and only able to see our frame of reference. There are
Hmm.
things that exist outside of that, and I if you don't have due process, how many examples do we need of whether it's the what was it, the gay hairdresser or makeup artist who got sent to the El Salvadorian prison,
Oh my
escaping that
God.
stuff, and it
Hmm.
took
Hmm.
so much national coverage and pressure for it to even be addressed, and then it took even more to get
Hmm.
it undone. This man did not do it, but if there was due process in place, it's supposed to avoid that. It doesn't always, but it's it could be worse. And so, like, to just ignore these kinds of things is dangerous, I think, for a lot of reasons.
Hmm. Well, and I think too here, part of this conversation is also placing the burden, and you and I talk about this, we've talked about this before, is that everything that we've gone through in the 2 pages and 2 hours,
Yeah.
but this is on the state,
Yep.
right? This is on the state.
For a reason.
Correct, because
Because we're
that's their
supposed to have some
burden.
sort of way to it's harder though with elected officials because of the way it's, once they're in office or in some sort of seat, it's very difficult because they have a
Hmm.
machine behind them the next time a cycle runs around. And so
But I think,
even that process is difficult, but at least the reason is because the burden is on them is because there's supposed to be some sort of thing where they're supposed to have the consent of the governed to be entrusted with it. And with that comes responsibilities for a reason.
hmm,
I don't like the burden
well,
shifting to the defendants and the defense attorneys and people that we can't vote out, you know?
right. Well, and so that's the power of the state, right? When
Yeah.
did when did everybody decide that they really love the government? I would like to know.
I
Because
don't
it's like,
know.
but I mean, my point, I guess, is this though, is that that conversation needs to be much, much louder. That the burden is not, so when Nick gets up there and with his horrible hair and his disgusting mustache and his too tight pants,
Ned
and
Sanders.
oh my God, you're right. Yes. But when he gets up there and acts like everybody owes him something, it's like,
Ugh,
sir,
I know.
but that's the thing. It's like, I'm sorry, sir, you work for the people.
Yeah.
I do not. So therefore, I don't owe anybody shit,
Yeah.
in case anybody's wondering.
Yeah, that
But
has been a difficult concept for some people in this community,
they do.
especially. Like, people, they're members of the public are entitled to privacy. They don't have to
Correct.
disclose anything about themselves that they don't want to, not to the government, not to you.
Hmm.
And a public agency does. Public
Yes,
officials
correct.
have to be forthcoming about their official duties in their official capacities. That
And
is what the access laws are for. That's who they pertain to. They don't pertain to us. Like policies about how they're supposed to release things or whether or not it jeopardizes an investigation, that only applies to how they are supposed to proceed with that information. We are allowed to share it, use it, send it, ignore it. We can do
mhm,
whatever we want with it because that is our right. Public agencies like Nick McClellan and the state, they don't have a right.
right.
They're an institution, not a person.
Yeah.
And he seems
I,
to just not understand that.
right. And I think too that conflating those two, conflating somehow that by virtue, like I said this to you when we were talking the other day. I'm used to actually having people contact me and know
Mhm.
who I am because I put my name on my work. I've had this stupid, horrible career that I'm sick of, but yet I'm still out. My name is still out there, but
Well, I'm
that
used to
still
having
doesn't
my
mean.
information. This is the first time I am not like, I'm back, like, I'm trying to see how far in this process I can get with protect protecting my privacy and still receiving information that I shouldn't have to forfeit my privacy to get or share. So this has been, I've gotten further than I thought I would, but I'm used to having my name out there too. But it's weird to walk both lines, I guess, because I when I say in real life, I mean like what I normally do. This is different, but it's because of how this case has unfolded and things that have happened to other people and the way it has proceeded, and it's it's not
Mhm,
unique in the sense that nowhere else has had some sort of corruption scandal or craziness, but it's just different than the other ones.
mhm,
I have not experienced anything quite like this. Like
mhm.
it's a different strain of ridiculous, I
Yeah.
guess.
Well, and yeah, and I mean, and we know that the carceral state targets people of color, low socioeconomic. We know that, right? We
Mhm.
know that has always been something. This has
Yeah,
never been perfect. It's been shittier. It's been shittier and less shitty.
yeah,
And on its good days, it's all right. But but part of it is is the whole conversation. It's about where the burden lies. It doesn't lie with the public.
mhm,
It lies with the state. It lies with, in this particular case, the state of Indiana, with Nick Cleveland, and with what is coming down the pipe in the next year and a half
yeah.
you know at, at soonest, right? So and I think that's an important conversation to have, and I think to empower people because we all kind of inherently know this, I think, but maybe forget, like that the it's not on us as citizens to have to prove our innocence. That's not
Mhm.
how this works. um it's not. And so it and people need to be reminded of that.
Oh, these jurors, man. She had a pros and cons list, and the cons list just out of things that didn't add up outweighed the other stuff. That is not the correct
What?
outline or baseline. That
Oh
is not
my
how this works.
God.
It is not like that. If there's things that are still not adding up, you still have answers. That's reasonable doubt, not a conviction. If you still
Oh,
have answers, or I'm sorry, if you still have questions, the prosecutor hasn't done their job. You don't just assume that it's the prosecutor's job I'm sorry, that it's the defendant's job to fill in those blanks for you because it's not. And they're going to have, if they have competent counsel, they're not going to give you those answers because they're going to be advised not to,
mhm,
because
mhm.
it's the state's burden, because that's how it's supposed to be. The problem is the jurors are not holding up that end of the deal. I
Oh
don't know
God.
how to, I don't know. That's a whole other issue because, we can't deal with those kinds of issues with the state because they love when jurors do that. So they're
Yep.
never going to address it. You're never going to see a judge take an issue with it or a prosecutor take an issue with it. Of
Right.
course, not when they're doing the burden shifting for them. but
Right.
it is something that does need to be addressed, and that, in my opinion, the only way it will be even acknowledged, let alone addressed, is by all of us just trying to educate people about that and the problems
Yeah.
with that. But it is probably going to be hard because even when um, they read one of the old transcripts from, I forget which hearing it was, with Diener and McClelland,
Oh my God.
and I always want to say, what is it? Pat Mahanahan? I forget his name, the public defender in Carroll County. They were part of the transcript was asking the jury questions, and they were trying to see if the jurors understood reasonable doubt and
Oh
that it was the
no.
prosecutor's burden to prove stuff. They're like, yeah, yeah, prosecutor has to prove its case, but it's so a defendant has to prove his innocence. And they were like, no, no, no. Like they were saying two different things that are the opposite of each other, and saying that yes, they could meet, serve as a juror and meet the criteria for doing that, which is that the defendant does not have to prove their innocence. But each one of them, it was is the most painful part of that transcript.
Oh my
They
God.
just could not understand that, that
Oh.
whether, like, you were supposed to assume he is innocent and that the prosecutor is the one lying, actually, until they prove otherwise. Like, that is probably a better baseline for jurors to start with, is to assume the state is making it up and bluffing
Yes.
and manipulating you, and they're doing it against an innocent person. And until the state proves their innocence of their case, like,
Yeah.
that's one of the things that's driven me crazy about this case, is that Nick has done more defense work for the state to defend against their shit investigation and shit police work. He's been an excellent defense attorney for the state. He has
Yeah.
not done much proving of anything, but
Mm-mm.
it's backwards. It's out of balance. It drives me crazy, and these jurors don't seem to understand it. The fact that she thought that was some sort of gotcha with her pros and cons. She just wishes Richard Allen supporters understood that at the end of the day, when she made her pros and cons list, the cons list just far outweighed the other side, as if that is even remotely how she was supposed to be making
Well,
decisions. It's not.
um, so
It's terrifying.
first of all, that makes me want to walk into the sea. Second of all, I do not want a jury of my peers.
Right?
Uh, third of all, what the,
Yeah, I'll
you know
send you the
what?
transcripts because it's hard. It's hard.
Uh,
It was hard for me to listen to it, but I did, because some of I just copy and pasted the transcript that was generated from his live,
oh,
and then I had to listen to it to try to make sure there weren't errors or misspeaks, or it didn't catch something right. I just listened to it, and it was difficult because the things they were saying, like, I just wish Richard Allen supporters would ignore the law, insert completely ignore juror instructions, the law, all of these processes that are supposed to be the juror's responsibility. They just did This juror and this journalist did not seem to understand that,
a
what they were
journal. Okay,
asking
I'm gonna have to
to
stop
do.
you right there. I'm gonna
I
stop you
know.
right there. I'm gonna stop you right there. That I would like to make an offer to any to any juror who wants to actually speak to somebody that is a journalist that is knows how to vet and protect anonymity and to treat you fairly without writing you into a sports page at their kids' high school. I can do that for you.
Well, there was an update after he posted the interview
Oh, I saw
from
it.
from the juror, yes, and she did clarify that those were not her notes from trial. She just went home at the end of the night, and she has a, quote, "great memory," end quote, and she just wrote it from memory. And I think that was even helpful because
Ah,
from her memory, what she remembered was factually incorrect,
oh
and that's
my
a
God.
problem, especially if that's what she was basing her decisions on at all.
Hmm. I could
I
live my
don't
whole life without hearing that.
I know.
Uh,
I get
my
stressed
God.
anytime people say there is, "Oh, this person on this like, there's I think it's only happened 3 times. One where there was a potential juror who said that they got I wonder if she's the one who was responsible for this post early on before the murder sheet interview with the juror. But there was a
I'm
post on Facebook about somebody saying the jurors learned after the fact that Richard Allen and Keegan Kline did actually know each other or something.
what?
None of that was brought up in trial, so
Mhm.
how would they have been briefed on that? But this lady
Wait.
also said that from her sources, she learned that Richard Allen actually was only feigning and malingering and all those kinds of things to um, to basically control and manipulate his his housing situation, as if he had any say. Like, there was nothing he could have done to change the safekeeping order. There was no behavior he could have exhibited to change a safekeeping order. These people think that he could have done all of these things to change that, as if that was an option, and it's not. It wasn't.
Um,
They're just making things up.
so here's what I'm going to do to get through the night tonight because this I'm going to choose to believe that guy is cosplaying as a journalist and as a juror and that he made all of this up because I can't.
Yeah. Well, he said that we
But
can either believe him or not because he vetted her. He's got the
okay,
court records from the being
sure.
called for jury notice, how much she got paid, and he
Mhm.
saw a blurred out photo of her and the other jurors with Judge Gold in the courtroom, I assume after sentencing. I don't really know when that would have been taken, but he says that was he did his due diligence
Mhm.
and that he's also never going to show that because he said he would only do this on the jurors' terms, and that was part of her terms, and she would like to respect the privacy of the other jurors, and
I
if
see.
like we can either accept it or not. That's the position we are all in.
Okay, so I'm going to give you just a quick rundown on what. No, but listen, this is something I actually
I'm
do
basically
know
just
about.
saying, like, updating. I'm not co-signing any of that.
No, no, of
That was the
course you're
update.
not.
Was trying to paraphrase it.
No, of course you're not.
Yeah.
But I'm going to just say this for anybody out there that that's not what journalists do. They don't co-sign bullshit because that's what that is. And that's not to say that it can't be approached in a because I believe if it's an actual juror and maybe it is. I don't know. Maybe they don't care. But I got to believe that there are some jurors that partook in this that do have. I mean, they went through a murder trial. Two little girls were murdered, right? But you could like trauma informed journalism says you trust but you verify.
Mhm.
You aren't held hostage by the person purporting to be who they are. Therefore, he should not have even run that story without at least getting something other than absolute nonsense. Like there needed to be an audio there needed to be something else. There's parameters, but journalists don't just say yes to everything.
Well,
That just
he said there was 40 emails back and forth
okay, great.
with this
Well, whatever.
person. I think that was,
That's
like, the juror like, he posted the pictures of the notice and how much the person got paid. He didn't post the picture, but he talked about it, and then he said in addition to that, I believe it was 40 back and forth emails.
yeah, and that's another thing is that journalists don't show that shit either. So, I mean, if he feels that insecurely about his work, uh, his notebook, then he should probably just not be in the biz because that's also something you don't do. You stand by your work without having to, uh, show receipts, right? That's not
Yeah.
something that happens. So, I wish him all the best and his career.
Well, I'm
I
gonna
know
say
that.
what I said earlier, and all I know is if a sports beat reporter had misreported the most basic standings and as many basic standings as he did with that juror, he would not be
Mm,
reporting in sports anymore. The fans would tear him apart. And
mm-mm.
so for him to treat people taking issue with factual errors as some sort of Richard Allen supporters just losing their mind. Well, no, it's
This
not
is
even about Richard Allen supporters. It is we're trying to get real answers. He's falsely equating that with some sort of we're just mad because the juror didn't like Richard Allen. Like that is I don't know
Who
how to help these
cares?
people understand that we don't know Richard Allen, we don't know Richard Allen's
Uh,
family. This is literally about the issues, the procedural errors, the systemic issues around this case, the fact that we still don't have real answers, and I can't help people like that. I don't know how to help them if that's what they think this is about. But
mhm.
he's go misreport that about some sports information and see how it goes.
Well, it just, but it does, it speaks to it. I get real pissed off about this kind of shit, and I probably shouldn't even have started down that road, but you just don't. It's not, it's not, you don't, no. Mm-mm. You don't. Oh, sweet. Oh my God. I am. I'm gonna go walk in the sea. I'm gonna go
Yeah,
walk
I
into the
did an
sea.
impromptu live instead for
Oh
like
my
4
God.
hours. It's just like having to talk it out because I'm like,
Uh,
I can't, I got, I have to process and be able to move on from it. So I'm like, I'm doing an impromptu. I'm gonna acknowledge these things, and then I'm gonna do my best to just ignore this person because
mm,
that person is not providing answers or anything helpful to anything. Nothing that
mhm,
juror provided us did anything other than confirm that the state and their case had nothing to do. Like, they spent more time trying to prove the confessions were valuable than they did what actually happened to the girls. They didn't substantiate anything that was said, and they walked back a lot of it because it wasn't what they presented it as in the first place.
mm,
And nobody has a clue what actually happened to those girls. All they can do is quote who they think killed the girls, and that's not
mhm,
how we solve crimes. It's just not.
mhm. No, it's not. And the thing is that the two supposed jurors that have spoken out, which maybe actually they actually the only thing that made me think it was a juror is the photo with Gull, and I'm not even kidding.
Me
Like
too,
I'm
I was
not
like,
being funny.
they would do something like that, wouldn't they?
Yeah.
'Cause they were
Yes.
all like, "Oh, the
She
you
would.
know, this
Yes.
lady liked Cecil and Oberg." Those were her 2 big they made the most impact on her, I guess. Those were the 2 she named. I'm like, "You've got to be fucking kidding me."
I
The
wonder if she
Cecil
was at the
search.
right. I
He
wonder if she was.
testified to what other phone users potentially experienced with other things
Oh,
because he couldn't
Cecil.
testify to what the phone data actually showed, which is what he was supposed to be doing. He testified to what other people on the internet experienced in a completely different has no bearing on what is at hand here.
Oh
That guy
my
made the
God.
biggest impression on her. And Oberg, who is 100% right 100% of the time, which is not a thing. Is not
Hmm.
a thing. I
Yep.
but
Yep.
those were the 2 most impactful for her, I guess. It's crazy, and she thinks that Andy Baldwin was coddling Richard Allen. She said
Okay.
coddled.
Okay.
She noticed that Andy coddled him. I'm
Huh.
like, "Okay, interesting." He's treated like a human being, like a client,
Mm.
and that's
Okay.
caught like, you can tell, like, they're bound the way it's not just that they shift the burden onto defense to prove things, they also shift unfair bias onto him as the baseline. It can't
Mhm.
just be they're treating their client with dignity and respect because that's the
Right.
professional thing to do. It has to be it's actually coddling him. Like, they're just it's gross, all of it.
I,
That part made me pretty mad.
well, and I mean, the thing is that, again, nobody has to believe in guilt or innocence, but nobody does. They don't have, she can make it, these people can make any observations they want, but I
Mhm.
think what the takeaway is that we need some serious,
And I'm
uh,
allowed to be very concerned about the effect of her observations on the
yeah,
verdict that,
correct.
and that was part of my life too last night is she kept, she started off with, "We're just regular people. We have real lives." I'm like, "Lady, so do we. I'm a
Hmm.
regular person.
Hmm.
I still need to be able to have these discussions even if they're hard, even though
Hmm.
I went on a whole thing. I'm aware that I'm pretty harsh sometimes. I'm
Hmm.
pretty direct. I don't have much of a filter, but I will even make a conscious effort if we can have some more, like if this is a juror, if these other jurors, if they're not gonna be willing to engage with the 100% predictable questions that we're gonna have, then don't come then I don't wanna hear from you at all. Like, what is the
And
point?
and that might be why, honestly, there hasn't been more coming forward because, I mean, there is a chance, and that's the thing that, and I'm only flipping out because I'm getting tired. But I mean, but part of it is, you know, jurors should feel like they should be able to have these conversations, right? I mean, and
Well,
I
isn't that
think
what they
in
did
this,
during deliberations, was debate this?
yeah,
Why should it be any different now?
well, and the thing is that, um, in this, I found it. There's a lot of issues, and I think it's interesting about the. I don't know. I think that it will be interesting to see what comes of the two interviews that we have. Let's just assume that Skip or whatever his name is had a real interview. I don't know what his name is.
He goes by Tim, and he told
Right.
you about all the different awards he won all over the place and all of the different outlets you can find him in, and he thinks
Mhm.
that somebody else doxed him
I see.
after
Okay.
telling everybody
Right.
his name
Right.
and all of the different outlets you can find his work in.
Oh, right. And that's another thing too. It's like your name is not being doxxed.
Yeah.
We need to not with that anymore either. But the thing is that you know, I think that those, I'm gonna have to go back. I don't think I can stomach the murder shits. I will go back and read the transcripts because to me, it seems like there are some interesting things that we're learning about the time that they were in the
Mhm.
jury room and about some of the things that they did.
At dinner
Some,
time.
I mean, just,
And
but
weren't
serious.
they carted back and forth by the police chief who was let go for being a dirtbag?
hmm
I have questions
the
about that too.
wait, say that again.
The former police chief who had to resign in disgrace that Nick publicly
Oh
condemned,
yeah. hmm
he was the one who was driving them back and forth or was either driving or escorting or
Oh yeah.
chaperoning.
Oh,
I
he
I don't know
was.
if he was the entire time, but yeah, that's who was in their ear the whole time, and also whoever Jason is.
Oh my
The other
God.
juror really liked Jason.
See, now this is a whole other kettle of fish, and I think that and it's also speaks to me just sort of the unseriousness
Mhm.
of the way that this was approached, and maybe it's defense. I'm trying to give the benefit of the doubt. Maybe it's defense mechanisms, like they realize they maybe didn't do the best with the information they had. But but I just cannot imagine slinging up with some good old boys, having barbecue with a nasty, having my photo taken with a judge. It just seems so weird to me. Like
Yeah.
it's almost like a TV show. It's like this people.
Mhm.
This is not a TV show. I mean, my God. Oh, gross.
Yeah.
Now I'm gonna have to go read it. You're gonna make me go
I'll
read it.
send it to you.
Well, so that went off the rails, but that's
Yeah,
okay.
sorry.
No, God,
Part of
no.
the
I
fun.
needed, I kind of needed that. But and
Well, it's a good reminder
everybody,
of why we're going back through the motion to correct error and
yes.
going back and reviewing the actual thing, because if the juror interviews are the last thing that is being put into the public, it just glosses over all of this and it kind of tunes it out. And so it does need to be brought back to the forefront for these reasons and
hmm
for a list of other reasons. Like, this is where we're starting. And, and eventually, as we go through issues, like, we will have to get at some point to the issue of the juror instructions and whether or not they were followed when we have
Well,
jurors coming forward and saying, no, they weren't actually, not the way they were instructed.
right. Well, yeah, I'm not kidding about going back through the transcripts and stuff because it just seems like some of that the seat being sequestered could have been taken by some to be kind of like a staycation, right? So they could have been treating it like it was just some time off at the luxurious Delphi Inn or whatever it
Well,
was.
this juror did not actually view it as that. And I do, because I would have a hard time with it. I can't act like I don't believe it because I can relate. I don't know if it actually is true for her, but she had a very difficult time being away from her family.
Oh, sure.
and
Yeah.
but still, like, it's nothing compared to, I don't know, being held in solitary.
I don't know. Yeah, after your judge jumped out the back window and went to go throw some pottery with
Yeah,
Tobe.
she only had 2 days to prepare, and it was very hard, and she had to tell her employer. Well, imagine having to tell your employer you're gonna be in solitary for the next 2 years because you went in actually like, she thought she was going in for jury duty, and she ended up staying. Imagine going in for a police interview thinking that you're gonna offer some information because these people who have this very public unsolved case are going back to the beginning finally, and so they're calling in anybody they talk to, and you think you're going in to help, and you end up in a maximum security prison for it. Like, that might be kinda difficult, so, but she just had a bunch of interesting takes, like, she wanted us to understand how hard it was for her, while at the same time telling us that he was just feigning his symptoms. Like, it'd
Hmm.
be real hard to be sequestered, but it wouldn't be that affected her, she can't sleep, she doesn't know if she'll ever be the same, but Richard Allen was just faking it. How she reconciles those 2 things is it it
Hmm.
It I get a pit in my stomach about it. It's
Yeah.
makes me mad and sad and furious, like, it's just and I'm just disgusted by it. It's
Hmm.
terrifying because there's no telling how many other cases out there have also been decided by
Hmm.
similar unthinking, selective.
Unserious.
Yeah,
Unserious. Like just.
it's scary.
All right. So, one other thing I want to talk. I mentioned to you about Sergio.
Mhm.
Maybe approaching him at some point to see if he would take a read through of bringing it back to the filings, to some of Nick's um, filings,
Yeah.
because I would be very interested to see what his take is. He would, I don't know if he could do it just from the transcripts, but I don't know. I was
I
thinking
think
about it,
he's
but
on the list of people that we're trying to see if there's enough of. Does that make sense? Like, he was able to do it with some people, but then there were others that we all would have liked to see, but there's not really enough public or interview statements. But I do think there is more
mhm.
than enough with Nick. I just don't know where he would fall on the list of people.
Yeah,
'Cause he is new to the case, and it's for
he's
someone who,
probably
yeah,
feeling overwhelmed.
well, he didn't. I thought he might be, and he didn't seem to be that way. It's more of just a I think he absolutely would. I just don't know. I'm pretty sure that Nick might actually already be on the list of people that he will be looking at, and I don't know where on the list, but I'll ask Amy and I'll figure that out because I think we would all benefit from that. I think that would be really a very good effort
I'd be
because I
very
think we'll also
interested.
learn a lot about where we should be looking next if
Hmm.
if we did that exercise.
Yeah, and I think where we should be looking next. So if we reconvene, if people are interested, we can do that. And I mean, we'll reconvene anyway. But
Yeah.
I think we should talk about the. I mean, we'll get through the rest of the motion to correct error at some point. But some of the responses where Nick mentions crazy shit,
Mhm.
like a cell phone or cell phone battery or whatever it is. I mean, all these things that he was like, oh yeah. And by the way, it's like, well, where did
Introducing
that
new
come from?
evidence in his replies
Yeah.
about Ron Logan removing a cell phone battery from a phone,
It's like you
and
don't say,
yeah,
huh?
interesting.
Wow.
Where'd you hear that, sir?
And that I will stick right in the four corners
Mhm.
of this appeal. I mean, my God. Um, but yeah, I would like to chat about that. But yeah, so I think that if people are interested, I'd be down. I don't know when, but we can figure it out.
Yeah. We'll just keep scheduling and rescheduling until we can actually do
Yep,
it.
we'll keep rescheduling and
That's always a fun
rescheduling
game.
and rescheduling and rescheduling. Yeah, that
It
was,
happens.
yeah, sorry about that.
No,
Yeah, but
it happens. That's why I don't even try anymore. I'm like, "Whatever." I'll just
yeah,
impromptu. If a window opens, I'll take it. That's kind of how it's been going.
yeah, yeah. Well, and I just, I've been gone for a while and I'm just like, well, I'll just dump back in. And I'm
Yep,
like, oh, what am I doing?
and stuff happens.
Yeah. So, but anyway, so yeah, we'll stay tuned. Keep checking back, I guess, people for
Yeah.
the Andy and All Eyes show. And don't forget to wrap your legs and arms around Tobe and the Tobe and Judge
I'm
Diener.
gonna be a hard pass on that one.
I'm gonna, but I do need you. I do need you to look up that scene from Ghost.
Oh, I remember it now. Now it's just ruined.
Yeah. Holy
I'm sure
shit.
DB could come up with some sort of AI
Oh
clip
my.
version of it or something to
Oh
torment us
God.
with.
Oh my God. Well, I'm gonna write some of this up, and I'm gonna maybe fire up my little Substack again to try to keep some of this in my thoughts, but also
Mhm.
just sort of like in the the zeitgeist,
In
if
the
you will.
ether.
Yeah, for sure. All right. Well, you have a great evening. Thank you guys so much. I appreciate people. Oh, geez, there he is, bringing up the end. No, not without porpoise. You're my habeas porpoise. Stone cold freak show. Okay.
I tried to say that word the other day when I was talking
What?
to my husband, and I couldn't say it because I kept I couldn't even say porpoise either. I just couldn't get any of the whole word out, and I just gave up. And I'm pretty sure it was concerned him a little bit because then at that point I didn't even know how to explain what I was
He,
having an issue with.
he was like 911. My wife is having a stroke. It's her eye. Oh God. Oh my God. Um, all right. Well, have a good night. And I will I gotta see if I can let me just see here if I can end this stream by cutting us off by telling people that I hate you all.